Hi, I'm Greg Dell, joined by attorney Cesar Gavidia, and we're going to talk about how to win a New York Life disability benefit lawsuit. Cesar, you've handled hundreds, if not reviewed thousands of New York Life disability denials and been involved in so many lawsuits against New York Life. But people, call you all the time and they go, look, I've done my appeal, I've been denied, and the only remedy left is to file a lawsuit because that's all that the ERISA laws give you. So how does someone win a New York Life disability benefit lawsuit?
Yeah, and when they call with that I just finished my appeal, and they're telling me I could bring a cause of action or legal action against them now. My heart drops a little bit because we know how important that appeal process is, and you could only hope that they included all of their medical records, that they included all of the support that they could possibly find from their doctors, all of external reports from and unfortunately oftentimes there's something lacking under those particular circumstances.
Why is your first thought to say what does their appeal look like, and why is that so important to you?
Well, because in terms of the litigation and how these cases at the federal court level under ERISA, how they're adjudicated, it's all based on this administrative file. And when you say the administrative file or the claim file or the administrative record, you're basically talking about the appeal. Mm-hmm. And you're talking about those initial claim documents that were submitted. Okay? So if the appeal that you've submitted mm-hmm. is not the most comprehensive, exhaustive, supportive appeal you could possibly put together, then at that federal court level, you could potentially have a really difficult time prevailing, because in most of these ERISA employee benefit disability cases, the court is hamstrung a bit in the sense that they are applying an abuse of discretion standard of review. And basically what that means is that they're giving the insurance company the benefit of the doubt that their decision was correct. That's at a legal level in terms of the law that they have to apply. They have to assume that the insurance company's decision was correct. And absent them abusing their power, the decision's going to stand.
Okay, so when we focus on someone's going, hey, do you think I can win my lawsuit? And when we speak to potential clients, which we offer free consultations all the time, the things that we always need to look at are two essential documents from the beginning. Number one, we need the final denial letter. And number two, we need the policy. Why are those two the most important documents that you need in order to evaluate whether or not you can win a lawsuit?
Sure. So first, the policy. That sets out all the guidelines, the terms, the conditions that have to be applied, how you essentially are eligible for disability. Okay, it spells out how long you're paid, how much you're paid, the remedies available to you if your claim is denied. All of that is spelled out in the policy. So it's really important to have that document. Any limitations, exclusions, all of that.
Right, definition of disability.
Right. As far as the denial letter is concerned, all the denial letters, the initial one, the final, the reason that's important is because the insurance company, when they deny you, they have to spell out and explain all of the reasons that they're denying you. If they relied on a particular doctor, if they relied on a specific report or record, if they conducted a internal review of your file, they have to explain how they arrived at these conclusions or these opinions. And the reason they have to do that is because under ERISA, you're afforded a full and fair review if you appeal it. Okay? So they have to give you all of that information. And if they don't, then there's a flaw in their review process, and that could potentially, either get you a remand at the federal court level, meaning it goes back to the insurance company, back to New York Life, or you could potentially win your case. And New York Life doesn't want you to do that.
Well, one of the things I like when a claimant's calling and they say, I have New York Life and I've been denied, right away for me, and before I've even seen the denial letter, is I usually know that that's not going to be a very strong written denial letter. Is that your opinion usually also when you get these New York Life denial letters? And by that I mean they're short, they're not specific, there's holes in them.
Sure.
And why is it good that there's holes in them?
Well, the reason that obviously is good that there's gaps or there's flaws or problems in their denial is because those are the essential kind of elements you need to say, hey, I wasn't afforded a full and fair review.
Right.
Or they abused their discretion. They shouldn't have done this way. They should have, done the following, or they ignored the following information. They could abuse their discretion, or the denial could have many, many flaws, many different ways.
So we talked about two things, the denial letter and the policy. But that's an initial phone call. Let me look at it. Let me give you my experience of 20 plus years of doing this and just say, I think we have a shot here. As a lawyer, I'm intrigued to want to see more. And what's more now is this administrative record and this claim file. And what that is, as you know, is that's probably hundreds, if not thousands and thousands of pages of information as to what New York Life looked at. It's every piece of evidence that they considered. There is nothing else, and that's one of the things I like about ERISA. There's no surprises. There's nothing further that's going to come in down the road. There's no outside statements. Anything that New York Life looked at and considered is in this claim file, this thousands of pages. And the way in which you win this lawsuit is to tear that claim file apart and start to put together a plan of attack and a theory to say, what New York Life did you do that was unreasonable? What did you do? What did you miss? What did you not review? Why did you get this wrong? How am I going to convince the judge that you did this wrong? But Cesar, that's the real factual argument. But the factual argument's only one piece of it because you have to then relate that to the case law. And can you explain what is this case law and how extensive is this body of case law that when you go forward with a lawsuit and have to present this to a court, that has to be applied to this massive amount of facts?
Right. So it's vast. It's quite extensive because ERISA is a federal law. So every federal jurisdiction has their own body of case law. And depending on where your lawsuit's filed or where your case arises from, that jurisdiction's case law is usually going to be binding upon the court. So if discretionary clauses are banned in your jurisdiction, then the insurance company may not have that advantage of being able to apply an abuse of discretion standard review. That's paramount. That's a huge advantage that the claimant may have. While in a neighboring jurisdiction, they're allowed to apply abuse of discretion standard of review. And your case, were it brought there, may be a loser 9 times out of 10 because of just that alone. Also, the way that they interpret what an abuse of discretion is, the ways that the insurance companies have violated, a full and fair review of your appeal, or how they have perhaps afforded more weight to their doctors versus yours. That could vary jurisdictionally, all right? So what we're doing also is vast research when we're involved in litigation and when we're filing your case against New York Life to basically extract and pull the most favorable case law to your facts, all right, so that we have the best chance of winning that case.
And what people don't realize, I always wish people could see inside of our brains of when they're talking to us, because we go down into what's our knowledge, how are we going to win this, what are we sharing? But when a potential client calls and they're talking to us, or I'm evaluating an existing clients of how to win their case, how many cases in ERISA do you think you've read in your life?
Oh, probably hundreds, if not thousands. I mean, it's
okay.
We're reading them every day.
So yeah, I mean, there's thousands.
Yeah.
And if we had to guess how many ERISA decisions there's ever been, in excess of 10,000.
Sure.
I mean, easily, right? Through going back till 1970s when ERISA started. So as we're evaluating a case, we're sitting there like that computer that you're watching processing, and we're thinking about all of these cases that we've seen to say, oh, they did this wrong, but oh, this court said it was okay, and then this court said it was wrong. But then, excuse me, as we know, every day we get updates on new cases. This world of ERISA case law is nutty. I mean, because it's so fact specific a lot of the time. One judge all of a sudden says, no, that's reasonable. The next judge says, no, I don't find it was unreasonable that they ignored 3 of the treating doctors and just had 1 who didn't even see the claimant. But yet you already had 5 cases that said that was unreasonable for that exact same condition. So we always call the ERISA, especially with case law, the wild, wild west. It is a freaking, it's a circus. I mean, it's absolute mayhem with the case law that's out there, trying to put together, a motion to win it. But I believe this is a benefit for claimants. This, knowing the case law, being able to be an outstanding writer and researcher and really practicing exclusively in this area, knowing the case law, gives a claimant a benefit because there is an entire world of cases out there that probably someone has the exact same fact pattern as to what you've gone through. Not just your medical condition, not just your policy, not just your occupation. I mean probably exact. And many times we can find cases of that same fact pattern that helps you. On the flip side, there may be your exact fact pattern out there that doesn't help you. That was something similar, and now the judge says, look, this is how the court ruled on this very similar fact pattern. So you have to be able to distinguish what the law is, what the facts of that case were, and argue in your favor. But let's assume, Cesar, you get a case and you do the research and you go, yeah, 3 out of these 4 cases are against you. Is that the end of the road for the claimant, or is there an option to still what we consider a win? What is a win, in these cases for a claimant with New York Life?
So obviously a win could be, the way most people see it is, I won my case. The court found in my favor. But you have to be realistic about your chances of success. And you have to listen to your lawyer who's got, years of experience and is essentially gives every day of his career to this area of practice. So you have to trust that. You have to know that when they impart advice to you and explain, these 3 cases really cut against us, we're going to have an opportunity to speak with them, see if we can resolve the matter, resolve the case. This isn't the end of the road. They may have a strong defense here, but we have these things that we're going to respond with. But be realistic about your expectations here. Be realistic about your chances of success.
And with that comes about being realistic is it's not all or nothing. We're going to go to the judge and get a verdict, or we're not. In almost every case we ever take, we're going to get some kind of offer on the table. And a lot of claimants don't know that. They may just think, I'm going to lose. But we're super upfront with our clients. We'll tell them from the beginning, look, we know pretty quickly this is a case we think we're going to win. This is a case we think you got 50-50 chance, 70-30, 80-20, whatever it is, and tell them. But when money comes on the table and people don't realize that, we're going to get you an offer. I'm not guaranteeing it, but I've never touched a case where we didn't get an offer. I know you haven't either, unless someone was a complete fraud and we found out after the fact. But we would never get involved with a case that was fraud because you're going to see it in the record. So there's going to come a point in time where New York Life is going to say, we're willing to offer you X amount of dollars. And the claimant at that point in time is going to have a decision to make to say, hey, I got a guarantee of money. Do I want that number, or do I want to roll the dice and put it in the judge's hands? And that's where we come in and say, look, here's your opportunity. There's money on the table. Do you want it? And we'll give them our opinion, because we're going to get, the more money they're going to get, the more we're going to get. And we're all about getting the most amount of money possible. So we'll say, here are your chances. But at the end of the day, whatever that client decides is fine with us. That's what it's going to be, because it's their money. It's not our money. It's the client's money. And so I want clients to understand, and people out there with these New York Life disability lawsuits, that a win may not be what you think, just, I'm going to get every single dollar I'm owed, because you're dealing with a multi-billion-dollar company, you're dealing with a court system, you're dealing with potentially years of waiting through a lawsuit, and you have the opportunity to get a level of certainty through a settlement, which can be a good thing as well. It may not be what you expected to get, but it's certainty, and it is a win. So many factors, but I think that the bottom line is, if someone is in this situation where they're denied, you need to take immediate action because there's statute of limitations. Obviously, a client wants to take immediate action because they haven't been already paid for at least 6 to 9 months, whatever's going on, and reach out to us, get us the denial letter, get us the policy. We'll review it, take whatever time it takes, get on the phone, spend as much time as needed with them, and let them know, hey, we think we can win or we think we're not going to win. And if we do take your case, you're not going to have to pay us anything unless we win. So it's great for the client. We do everything we can to advocate for them. We're vested in what they need, and the goal is to get them paid as much as possible.
Yeah.
So if you're someone out there with a New York life disability denial, feel free to call Cesar or myself. No matter where you live in the country, we're available to assist you, and we look forward to the opportunity to discussing your New York life denial.